Hello, my name is Dr. Mahipal Rathod, and in this video I will discuss the legal reasoning portions for CLAT examination. Students often find the legal reasoning portion a bit difficult, but this is the most important part for the CLAT exam and you need to be very thorough with this. So in this video I will discuss how the questions are framed and how to solve them based on the principles and facts provided. Now, first of all, what is a logical reasoning question? See, it is based upon two concepts. The first is logical reasoning, and the second is law. So, whenever a logical reasoning question is based upon law, it is a legal reasoning question. What it does is it gives you a legal principle and then it also gives you some facts. Now, on the basis of these principles and these facts, you have to identify the legal consequences that can be derived from the question. You need to apply the principle to the facts and you have to select the most appropriate option. Why do I say most appropriate? Is because sometimes more than one options can be correct. You will feel while solving questions that even two or three options can be correct, but when you analyze the principle and the facts, you can see that one of the options will be more correct according to the given facts. For solving the legal reasoning questions, you have to follow some golden rules. The first of which is never question the given facts. Now, you might see that the facts sometimes which are mentioned are exactly opposite of what it is in real world. But you have to completely ignore that and you have to take it for its face value. Second, do not assume anything by yourself because you should not assume anything in law. You should go by the given facts only. You will be given a set of principles or a single principle or sometimes even two principles, and you have to assume that the principle is always right. The principle can never be wrong for that question. Never take the principle for another question into the next question or the previous question. Always believe that the principle which is given in a particular question is true only for that question. Whatever prior knowledge you have, prior legal knowledge about any legal principles or law, you should keep it aside while solving the problems because otherwise you won't be able to arrive at a correct answer. You should go only by what the principle mentions in that questions. As I already said that sometimes the facts or even the principle would be exactly opposite of what the law should be in real life, but you don't have to think about it. I will give you an example to prove my what I'm trying to say here. You read the first paragraph, the principal might say that anyone who smokes during a prayer in a church shall be banned from entering any government building for 1 year. Now, you know that the church and the government are two totally different organizations. The church does not control the government and the government does not control the church. So it is not possible in real life that the government can ban someone who smokes in a church. But if a question says so, you have to believe this to be true. Do you understand? Also, one more important fact, never fall into an emotional trap. What do I mean by emotional trap? Sometimes you might feel that the situation which is given in a question is is of a very emotional nature. You would feel for someone, you would feel that this particular person should not be punished or should be punished, but you should not go according to your feelings, your own heart. You should go according to what the principle says and what the facts are saying in the question. Always arrive at your answer looking at those. Never pick an option just because you think it is right. I will give you a scenario here to make you understand. Let's say that Ramesh goes to a shop and he purchases something worth 500 rupees from a shopkeeper and he gives the shopkeeper a 1000 rupees note. So the shopkeeper pays him back 100 rupee notes. He pays him 500 rupee notes which are fake. So as soon as he reaches home, he realizes that they are counterfeit. But it is too late in the day, maybe it is already night, and he decides that he will inform the police the next morning. But the same night there is a raid on Ramesh's house, and he is found by the police to be guilty, and the court finds him guilty of the crime of counterfeiting. Now, you might say here that Ramesh was not guilty and it was not Ramesh's fault. He was, let's say, duped into counter having the keeping the counterfeit money. But according to the law, he was caught with counterfeit money and he has to be punished. He is found guilty. So that is what I'm trying to make you understand here. Never fall into an emotional trap. Be aware of any emotional situations that are given in the question. Also, never pick up choices which are moralistic or preachy. What do I mean by moralistic or preachy? Like, you should never pick answers with generalized things like you should not steal from anybody or thieving is a bad act. Maybe it is. Yes, in real life, we know it is a bad act. You should not steal. But in the question, it might not be the correct answer. And so, please be very careful of such options. You should always base your answer on legal or technical footing. Now, coming to the solving questions or solving the cases part, first of all, read the principle completely. Do not read it half or read just one line and think that, oh, I know this by the article 14 or this principle is mentioned in the constitution which I studied in class 11th or 12th. No, please read the principle completely at least 4 to 5 times if you are not sure what it means. Also, at that point, do not bother anything else. Do not bother about anything else than the principle. Do not mix it with your own knowledge, as I have already told you earlier. In the principle itself, look for words like or, and, until, unless, provided, or only if, because these are determiners. So these will determine what the principal wants to say, what situation it wants to exclude, what situations it wants to include. So these words are very important. Read the lines containing these words again if you don't understand them, or if you are having difficulty in reaching an answer, please read the line which has these words in it again. So we'll start with our first case. The principle, as you can see, is the first part of the question or the case. It's a small part which says here that every person has the right to defend his or another person's body or property if there is reasonable apprehension. See, I have highlighted the word if here. If there is a reasonable apprehension of danger to such body or property. So now we come to the facts of the case. The facts are Leela Meenamma Iyer is a well-known lawyer and a feminist. She usually works till late, and one day when she was leaving her chamber for home, two men started following her and harassing her. She raised a hue and cry, and her colleague Ram Arora, who happened to be passing by, heard her. Ram started calling out names to the other men, and they got into a fight. Ram, being strong, he soon had them begging for forgiveness. As they were trying to flee, Ram picked up a brick lying nearby and hit one of the men on the head. As a result, the man died. Now, Leela Iyer decided to advocate Ram's case since she owed him her life. She pleaded on the grounds of right of private defense for him. And now, can the court absolve him of his crimes? Can the court absolve Ram, or should the court find him guilty? So, we will have a look at our options here. The first option is Ram should be acquitted since he was trying to protect himself. Now, he was not trying to protect himself, he was trying to protect Miss Iyer. So, the first option is automatically cancelled out or ruled out. The court should not press charges on Ram since he was trying to save Leela and the right of private defense extends to protecting others. Is this correct? Yes, the right of private defense does extend to protecting others. You can read it here. Of defend his or another person's body. But should the court not press charges? No, because Ram has murdered someone. Now, the option or the third option is Ram should be punished for murder. This is the correct answer. Why? Because Ram did hit someone on the head while they were trying to flee. That means, see, you can read here that they were begging for forgiveness as they were trying to flee. Ram picked up a brick. And the principle clearly states that you can only defend yourself when there is a reasonable apprehension of danger. So here, these men were already trying to flee, they were running away. Even after that, Ram picked up a brick and hit them. So there was no reasonable apprehension of danger here, and hence the correct answer is Ram should be punished for murder. Now, should Leela be punished? No, because she did not commit the murder. So this option is ruled out. We'll see another case. Here the principle says every person is entitled to freedom of conscience and to profess, practice and propagate his religion subject to public order, morality and health. The key word here to look for in principle is subject to. Now you can read the facts here. It basically says that a man from Muzaffarnagar slaughtered a cow in the name of religion, and at that point of time there existed an prohibition on the slaughter of domestic animals. His neighbors, who were Hindus, they felt that Abdul's act had hurt their religious sentiments and they instituted a suit against him. Now, should Abdul be prosecuted for the slaughter of the cow? Let's see our options here. First is no, it was part of Abdul's religious practices, hence he should be acquitted. So the first part of this sentence is true. It was part of Abdul's religious practices, but should he be acquitted? No. Why? Because the religion is subject to public order, morality and health. So it is subjected to some restraints. Second, yes, Abdul can and should be prosecuted since he hurt the religious sentiments of his neighbor. This reason is completely wrong. We do not have any really hurt religious sentiments that are mentioned in the principles. It mentions only public order, morality and health, no hurting of religious sentiments. The third option says that Abdul should be prosecuted since his act amounted to cruelty. Does the facts or the principle anywhere mention anything about cruelty? No. So the final option says that he can be prosecuted because the state has a right to regulate the freedom of religion in the interest of public order. This is the correct answer. As I have told you that the state, you can see it in the principle, the state subject to public order can regulate the right to freedom of conscience and to profess your religion. Also, on this basis only, the administration had prohibited the slaughter of domestic animals at that time. So when Abdul slaughtered a cow, there was an express order of banning the slaughter of milch animals or domestic animals, so he can be prosecuted for public order, infringing upon public order. Coming on to the next case. Here the principle says a person cannot claim damages for injury from a risky activity which he voluntarily undertook, knowing well the consequences that could arise from it in the usual course of events. What does this mean? It means that a person cannot claim any money or any claim from someone if he voluntarily undertakes a risky activity, if he himself puts himself in harm's way, when he knows what harm can come from that activity. But this should be in the usual course of events or how normal activities work and not in unusual circumstances. The second principle says that a master is liable to compensate for acts of his employees, servants done in the course of employment. Pretty straightforward. So the facts here are that there are two rival steel companies, TSPL and JISCO, and they both provide bus services for their employees from the nearby bus depot. Now both the companies have separate buses, but one day Mr. Adhikari, an officer of TSPL, he boards the bus for JISCO employees by mistake. And on the way home, the bus suffers an accident and owing to driver's negligence, therefore people are injured and Mr. Adhikari is also injured. So can Mr. Adhikari claim compensation from JISCO for the injuries sustained? See, Mr. Adhikari is an employee of TSPL, but since he was riding in the bus of Jisco, can he claim compensation? We will see the options. First of all, let's see the no options. So the option D says no, because Mr. Adhikari is an employee of the rival company TSPL. This is wrong. Why? Because even though he is an employee of the rival company, Jisco's Jisco's owners are responsible for the acts of their employees. In this case, the driver of the bus. Here it says no, Mr. Adhikari voluntarily undertook the risk by boarding Jisco's bus. Two things are wrong here. Firstly, Mr. Adhikari did not voluntarily undertake the journey. He boarded that bus by mistake, as the fact clearly mentions. Also, boarding a bus is not a risk usually. It is a very unusual circumstance that a bus has an accident. In a normal day, in our day-to-day lives, we do not board bus and think that okay, this bus will have an accident. It is a very rare occurrence. Okay, so this option is also wrong. Coming to the yes options, option B says that yes, he can claim compensation because Mr. Adhikari boarded the wrong bus by mistake. See, this option does look right, but is it completely correct? Can he claim compensation just because he boarded the wrong bus by mistake? No, he can claim compensation because the owners of Jisco are responsible for the driver's action. Let's read option A now. Since the driver had a duty of care towards the passengers and the accident was not something that was expected to occur in the usual course of events, he can claim compensation. This is completely correct, as I've already explained, and we have ruled out the other three options. Coming to the next case, a person imposing total restraint on the liberty of another, thereby causing another to believe that his movement is curtailed, is guilty of false imprisonment. So the facts here are that Shania and Cindy are amongst the two finalists of Miss India crown. Cindy considered Shania to be her biggest rival, and before the finale, she invited Shania to her house and locked her inside the storeroom. Now the storeroom had another exit behind the cupboard, but Shania was unaware of the same. She sat and wept while Cindy won the crown. Later, she let Shania out. Is Cindy guilty of false imprisonment? Now, you need to decide here whether Cindy is guilty or not. So, let's see the options here. The first option is no, because there was no restraint on Shania's movement. She could escape from the other door. Is it true? Yes, theoretically it is. But as it is clearly mentioned in the facts, that she did not know that the store had another door, so she could not escape. Now, answer B is option B is yes, because Cindy ruined Shania's chances of winning the crown. But winning the crown has got nothing to do with false imprisonment, so even this option is not correct. The third option is because Shania reasonably believed that her freedom of movement was curtailed. This is true. Why? Because she did not know that the store had another door. So for Shania, the only door was the one which was locked by Cindy. So she could not move freely, and hence her freedom of movement was curtailed, and that is why she can put a charge on Cindy of false imprisonment. The last option you can see is that Cindy was justified. Everything is fair in love, war, and competitions. Well, everything is not fair in law, so this option is automatically ruled out. The principle here says that the tort of defamation, tort means something, an act which is illegal. So the tort of defamation is said to be committed when a person causes injury to another's reputation in front of others without any lawful justification. The facts here read that Kamal Kapoor read about the miraculous healing powers of Baba Shamdev in the newspapers and decided to pay him a visit in the hope that he would be able to cure his daughter Kamla of her sleepwalking. After weeks of treatments involving a handsome fee, prescriptions of expensive medicines, powders that he claimed were made by him using special herbs, Kamla was not cured. Now, Kamal Kapoor was disappointed with the ineffectiveness of the treatment and the heavy cost. So he wrote a letter to Baba Shamdev accusing him of being a cheat and a liar, and also misrepresenting facts and defrauding people. Baba Shamdev handed over the letter to his lawyer, who filed a suit for defamation on his behalf. A suit of defamation is a legal action that somebody takes on another person when he thinks that the other person has defamed him. That means he has bad mouthed him in the public, he has said things that are not good about him, which will lead to the decrease in prestige or the social status of the person. So that is a suit for defamation. You might read in the newspapers that many politicians and film stars often file suit of defamations on newspapers, on journalists, or on other newspapers, or on other film stars or politicians when they have very bad things to say about each other. Coming back to the question, will this suit succeed? Let's have a look at the options. The first option says that yes, the suit will succeed and Kamal should be held guilty for slander. We'll check out the other options first, then I'll explain why this is wrong. Second is Kamal should be held guilty for libel. The third says Kamal will not be held liable for defamation. And the fourth is Baba Shamdev should be held for fraud. So first of all, option D is totally wrong because the facts and the principles do not mention that whether he is actually a fraud or not. So we are no one to decide that. Third, Kamal will not be held liable for defamation. This is correct because he wrote a letter and the principle clearly states that the defamation suit can be filed only when such things are said in public. Okay, it should be said in public in front of others, you can see here. So option C will be correct because he wrote a letter and he did not mention anything to the public, so Kamal cannot be held guilty. This automatically rules out option B. And see, we are no one who can say, we cannot say that Kamal will be held guilty or not. We have the facts to analyze, and according to the facts, we know that he cannot be held guilty. Option A automatically ruled out because the suit will not succeed. Okay, so do you understand here? Now you should not let your personal favorites or your personal preferences in such questions to come in. Always look at the facts, analyze the facts, read the statements very carefully, and on the basis of that only decide the answer. Now someone here may be a fan of some film star or some other celebrity or politician which are mentioned in the questions, but you should not let your personal opinions cloud your answers, your judgments. Coming to the next question, the principle here, it says that a person who brings a potentially dangerous thing on his land for use, and if such a thing escapes and causes damage, then the injured party can claim damages, provided is a very important word here, that the dangerous thing was harmful to the injured party in the usual course of events, not considering the escape. See, you should underline such words, provided, not. They give you determiners, that is, they determine what kind of situations will the principle be based upon. So here it is clearly mentioned that if only the dangerous thing harms other people, then such claims can be made. Okay, now coming to the facts, you can see that Pethalal is a member and the owner of a housing society in a 12-storied building with 30 flats. He occupies the ground floor. Last month, he visited a trade fair in Germany. He came across a new model of a generator, decided to buy it for his building since maintenance and upkeep of the building was his responsibility. He got the generator installed in his storeroom on the ground floor. It was running well. All the residents were happy. One day, the generator short circuited, thereby damaging the building, thereby damaging the electrical equipment of Mr. Bhinde, who lives on the first floor. Now, Mr. Bhinde filed a suit against Pethalal and prayed that he be held liable for the damage caused, wholly and strictly. Will the suit sustain? The facts that you need to highlight here are, first of all, Mr. Pethalal is the owner of the housing society. Secondly, the generator was installed in Mr. Pethalal's house. He installed it in his own storeroom. And secondly, when the generator short circuited, electrical equipment of someone living in that building was destroyed or damaged. Okay, let's see our options. The first option says that yes, Pethalal should be made strictly liable for the damage caused to Bhinde. See, we'll check out the other options also. Then I'll tell you why this option is wrong. The second says no, Pethalal is not liable for the damage caused to anyone at all. Pethalal and the generator company are jointly liable. This is automatically cancelled out, ruled out, because the generator company is nowhere in the question or the facts. The fourth says that Pethalal should be held liable as the generator is a dangerous thing. The generator is not a dangerous thing. It is nowhere mentioned that it was a very dangerous thing. Even if you consider it as dangerous, you should read the principle here again. It clearly says that first of all was harmful to the injured party in the usual course of events. Now the short circuit is not a usual course of events, okay, it's a very unusual event. It does not, just like an accident, it does not happen very often. It is a very unusual course of event. Also, there was no escape of anything. The generator did not escape and go to Mr. Bhinde's house. So considering both these options, the correct answer here will be no. Mr. Pethalal is not liable because the generator is in his storeroom. It did not escape anywhere, and also, as I said, that it was a very unusual course of events. A short circuit is not a usual course of events. Coming to the next case, an offer will be considered to be a valid offer only if a person intends for it to result in a binding legal obligation. The facts here are, Aaron is Melissa's younger brother, and one day, returning home exhausted, he asks his sister to bring him his protein shake from the kitchen. She refuses to do so. Then he says, "If you bring me my protein shake, I'll become your slave for a whole week." She brings him the shake, and the next day, she demands different things from him. But Aaron refuses to do any of those activities. Angered by this, Melissa decides to file a suit against her brother, claiming that he was her slave. Will she succeed? See, first of all, in usual circumstances, no brother sister would go to court over such small issues. So you now you see what I was telling you earlier, that sometimes the facts that you get will be completely opposite the reality. But again, because the question says so, the case says so, we have to assume it to be true. So let's see what are the merits of Melissa's case. Will she succeed? Let's have a look at the options. The first option says that yes, Aaron should honor his statement and become Melissa's slave for a week. Is this correct? No, this is not correct. Why? Because Aaron had made an offer, but that offer was not a legal obligation. They did not put it down on pen and paper and sign it. So there was no legal binding agreement between those two. Second, Melissa tricked her brother into the agreement. No, this is completely wrong, because Melissa did not trick her brother into the agreement. He agreed by himself. The third option says that no matter what the intention was, the fact remains that Aaron did agree to the offer, thereby giving his acceptance, resulting in a valid contract. The contract was not valid because it was not legally binding. It was just a verbal offer. So again, this is also wrong. And the fourth option is correct, which says that no, Aaron did not intend for the statement to result into legal obligation. Here the principle is a very small one. Time is of the essence. Time is the essence of a contract. The facts are, Ghoshwal Woolens Limited, an apparel store in a town of Bajipur, More than half the people in the town buy clothes from this shop, so it is a very famous shop. They are known for their quality and reliability. In the month of October, Mr. Ghoshwal, the proprietor of the proprietor of Ghoshwal Woolens Limited, he entered into a contract with Mr. Basu. He agreed to supply 1,000 pieces of woolen apparel, including sweater, muffler, gloves, etc., to the apparel store by November end. He was given half the amount as advance. However, Mr. Basu failed to supply the woolens within the given period and he supplied them in the month of February. So you can see that instead of November, he is supplied in February. Now, Mr. Goswal accepted the stock. Since he could not sell any of it, he asked Mr. Basu for reimbursement of the money which he had paid Mr. Basu. Is Mr. Goswal entitled to compensation by Mr. Basu? Let's have a look at the options. First of all, let's have a look at the no options. As option D says, no, Mr. Ghoshwal should have known that Mr. Basu could have defaulted and should have made alternate arrangements. Is this true? No, we are not, they have not mentioned anything about Mr. Basu that he can default or he could have defaulted. So we have to automatically rule this out directly. See, wherever you get extra information that is not at all provided in the facts and principles, you rule out those options. Then we can see the no option. No, Mr. Basu did supply the stock. He will not be made to pay damages. Is this true? No, because Mr. Basu supplied the stock late and it is clearly mentioned in the principle that time is the essence of any contract and they had a binding contract between them. The third option says that since Mr. Ghoshwal's rivals did better business than him, we don't have any information about any of the rivals of Mr. Ghoshwal. So this is also ruled out. So option A is correct. That yes, Mr. Ghoshwal can receive compensation because he's no longer has use of the woolens. It is already February. Winter will be going away. From March, summers are upon us. So all those woolens that he bought, they will go for, it's a waste for Mr. Ghoshwal. He cannot sell them now. So he has incurred huge losses. So option A is correct and he can be compensated. In this case, the principle says that an employer is responsible for the acts of his employees in the course of employment. The fact states that Raja owns a restaurant in Chandni Chowk. Rani is employed in this restaurant as the head chef. She has worked in his restaurant for more than a year and she's on friendly terms with the owner. Now, on a day when there are few customers, Rani asks for a day's leave to visit her mother and also she asks that if she could borrow his car for the day. Raja sees no harm, but Rani has not driven a car since 1 year and she has an accident. She loses control, she kills one person and severely injures two others. The injured persons lodge a complaint against Rani and claim that Raja should also be held vicariously liable. So the injured persons are saying that Rani, who was driving the car, along with her, the owner of the car should also be held responsible. Now you have to decide. The options say, first of all, both Raja and Rani should be held liable. Is this correct? No. Why? Because Raja had nothing to do with the accident. Raja did not cause the accident. It was only his car that was being used. So only Raja should be held liable since he is the employer and hence vicariously liable. This is also wrong because again, Raja was not driving the car. Raja did not have anything to do with the accident. He was sitting in his restaurant, most probably, or maybe somewhere else. So option C says that only Rani should be held liable since it was entirely her fault. See, this is true because Rani was driving off duty. This is the main point that you need to see in this question. See, the principle clearly says that in the course of employment, that means when the person is working for the employer, only then anything he or she does is liable. Those acts are liable. But here she had clearly asked for leave and then she went. So she was not working in the restaurant, she was driving a car in her personal capacity going to meet her mother. So Rani should be held liable, it was entirely her fault. And the last one says neither Raja nor Rani should be held liable, the pedestrian should have been more careful. No, this is completely wrong. We don't have any information about this. In this case, the principle says that unreasonable interference with the use or enjoyment of public property causes public nuisance, the removal of which is the sole responsibility of the state. Now the facts here are that Shania and Varun were strolling in a public park maintained by the Brihan Mumbai Mahanagarpalika. After walking for a while, they sat down under the leaves of a banyan tree which provided shade. In numerous places within the park, there were boards that prohibited plucking flowers, harming trees, disturbing the serenity of the park. Serenity means the peace or calm. So, do not disturb the peace of the park. Now, Manu Dada, known for his notoriety, happened to go to the park the same day and carried with him an electric saw. Electric saw means a cutter which works on electricity, which made a loud whirring sound. Using the same, he began to cut the banyan tree under which Shania and Varun took shelter. Now, Varun and Shania sue Manu Dada for public nuisance in the park. Decide. The first option that we see here is Shania and Varun can sue Manu Dada since the park prohibited causing damage to the trees. Is this true? Yes, the park, you can see here, there were boards that prohibited plucking flowers, harming trees, and disturbing the serenity of the park. But can they sue Manu Dada? No. I will tell you why. Coming to the second option, Manu Dada should be held guilty since he destroyed public property and disturbed Varun and Shanaya's date. See, Varun and Shanaya's date has got nothing to do with keeping the serenity of the park. So this is not the correct reason. Maybe he can be sued, but this is not the correct reason. Okay. Third is Varun and Shanaya cannot sue Manu Dada for public nuisance. See, this is a correct answer. Why? Because if you read the principle, it clearly mentions that only the state, it is the responsibility of the state. So the state can hold Manu Dada responsible. The state can sue Manu Dada, but Varun and Shanaya cannot. This is the reason that the first option is also wrong. Why? Because Varun and Shanaya cannot sue Manu Dada. Only the state can sue Manu Dada. It is the responsibility of the state to prohibit such activities of public nuisance and removal of whatever these causes of public nuisance are. Okay. So coming to the next case, the first principle in this says the only principle. A proposal made by one party and its acceptance by another with the intention of establishing legal relations is an agreement. The facts here say that Sahil goes to the Great Indian Bargain at an exhibition in Gymkhana grounds of Mumbai. Now this person, Sahil, he sees that on a window there is a beautiful painting, and along with the painting there is a board which says paintings for rupees 500. He knows that the painting which is kept in the window is more than rupees 500, so he immediately goes inside and asks the seller to sell him the painting, but the seller refuses to sell him that painting. Now Sahil sues the seller, claiming that he had breached the contract. Now which of the following is true? First option says Sahil will succeed since the marked price of the painting was rupees 500. This is wrong because in the glass the painting was kept and it was written that paintings for sale. It was a paintings and not clearly mentioned that it is this painting which is for sale at 500. It just said that in this shop. It meant that in this shop you will get paintings for rupees 500. So the second option is Sahil won't succeed since the marked price was merely an invitation to offer. So this is the correct option. It was an invitation calling people inside that here are paintings you can buy for rupees 500 in this shop. So please come inside. Okay, the third option says Sahil will succeed since the marked price was an offer, and by agreeing to buy it, he had given his acceptance. This is wrong because the marked price was not an offer for this that painting which was kept over there. Okay. Again, the fourth option says that Sahil won't succeed since he knew that the true value of painting was worth much more. This is not a correct reason. It was that the value was much more, but this cannot be a basis of the charges which have this cannot be the basis for the claim. The only correct answer in this is answer option B. Coming to the principle here, when one of the parties to a contract is in such a relation with the other party as to be able to dominate his will and uses this superior position to obtain the other party's consent to a contract, he is said to be exercised undue influence. Such a contract is not valid. This means that if you have power over someone and you make them do something forcefully, that act is not legal. You can challenge it under by saying that undue influence, you are using undue influence over such a person. So this is the gist of the principle. The facts here are that one Mr. Vijay Jain has three sons. So what he does is, see, first of all, two of his sons are married. Amar and Bharat are married. Bharat again has two sons. So these are the grandsons of Mr. Vijay Jain, and one daughter, so one granddaughter of Mr. Vijay Jain. Amar has also one son, his name is Divakar, so this is the third grandson. Now, on the occasion of Mr. Vijay Jain's 75th birthday, he gifts some of his land to his sons, and he gifts the largest piece of land and all his farms and orchards to Divakar. So clearly, he has a favorite grandson, Divakar, to whom he has gifted the most amount of property. Now, Bharat and Chaitanya, they sue Vijay Jain. The sons, they are suing their father, claiming that his consent has been obtained by undue influence and hence the transfer of property to Divakar is void. Now, these sons are saying that this grandson, Divakar, he had undue influence over his grandfather, and that is why he got these papers signed by him by force. That is what they are intending to say. Okay, now you have to decide what's the correct answer. So the first one says that gift is valid since there was no undue influence. This is the correct answer. It can be correct. Okay, we have no information about any undue influence, so this might be correct. Let's see the other options. The gift is void since Divakar coerced his grandfather into giving him the lands and orchards. Is it true? No. We have clearly, there is no written fact that Divakar coerced his grandfather. Coerced means forced, that he forced his grandfather. The third option says that the gift is void since all the three sons of Vijay Jain should be received an equal share. No, we are not concerned with equal distribution here. The question and the principle, they nowhere they say that the property should be divided equally among sons. So Vijay Jain can distribute his property as he likes. The final option says that Bharat's sons and Amar's son should receive an equal share of the property. Again, we have no principle which says that property should be divided equally. So automatically the first option which we have already seen is correct, is the most correct answer, and so the gift is valid and Divakar can enjoy all the property and all the orchards. In this case, the principle says theft is said to be committed when a person removes a movable property from the possession of its owner. The important word, the key words here are from the possession of its owner dishonestly with a view to take the property or to profit from it. So coming to the facts now, the fact says that Lily, who is a foreigner, she is visiting India to attend a wedding in Jaipur. She reaches Jaipur 2 days before the wedding and she decides to explore the city, shop and enjoy the delicacies. While she was roaming around, While she is roaming around in Jaipur, she drops her wallet on the pedestrian on the pavement. Now she moves on without realizing that her wallet is gone. But Chintu, who was a helper at the chart shop, happened to notice the incident and he picked up the wallet and kept it with him. Is he liable for theft? Let us see the options. The first option says no, Chintu is not liable for theft because the wallet was not in her possession. This is true. The wallet was dropped by Lily and she did not lose it. She did not know that it was gone. So according to our principle, which says that the removal of the property dishonestly, so here there is no removal of property dishonestly. Chintu found the wallet on the pavement, so this is correct. But let's have a look at other options as well. Maybe something is more correct. So yes, because he was unjustly enriched by something that did not belong to him. See, this is true. He was enriched by something that didn't belong to him. But was it unjust? No, it was not unjust because he did not steal it. He did not take it forcefully from Lily. The third option says that yes, because it is morally wrong to steal. It is true, it is morally wrong to steal, but as I mentioned in the very beginning of this lecture, do not give moral or preachy standings here. Everyone knows that it is wrong to steal, but you do not have to bring it here in this question. You do not have to bring it as it is not mentioned in the principle as well as the facts. So this is automatically gone. The fourth option says that no, it is Lily's fault. She should have been more careful. This is true. It was Lily's fault. She lost her wallet. She dropped it on the street. But is this more correct than option A? No. See, you can see that D is kind of correct. It is kind of right, but the most appropriate, the best option here is A. And because it is based on technical grounds, okay? It is not based on some assumptions. You understand what I'm trying to say? That option A is more technically correct, and hence we will choose our answer as A. Coming to the next case, the principle here says that the owner of a place is responsible for its maintenance. Pretty simple. Coming to the facts, Silver's gym is owned by James Silver and the gym has many members including Rohan. One day while running on the treadmill, the belt gets stuck, and since Rohan was running on a high speed, his sudden brake causes him to fall and hit his head on the dumbbells lying nearby, thereby causing him head injuries. James Silver blames the accident on the manufacturer of the gym equipment. See, James Silver is trying to shun responsibility here. But can he escape liability? Can he transfer the blame on the manufacturer of the gym equipment? Let us see the options. Option A says that yes, he can escape liability. It was not his fault because the equipment manufacturers, it was the equipment manufacturer's fault. Is this true? It can be true. Let's have a look at other options. Yes, it was Rohan's fault that he was running at such a high speed. No, this is completely wrong. Okay, we do not have any information that running, it does not say anywhere that running high speed should have been prohibited or the machine was not capable of handling high speeds. The third option says that James is responsible for the maintenance and upkeep of Silver's gym. Okay, so is this correct? Yes, this is correct. He cannot escape liability because the principle clearly says that the owner of a building is responsible for its maintenance. And finally, Rohan voluntarily agreed to the risk by joining the gym. No, there is no risk in joining a gym, or even if there is, it is not mentioned in the facts or the principle. So this is wrong. Now you can say that it was equipment manufacturer's fault entirely. This is where you have to take care of your own assumptions. You have to keep aside your own bias. Maybe you feel that it is the manufacturer's fault. Maybe you feel that no, it was not Mr. James Silver's fault. But again, in the question, you do not have to keep your bias in. You have to take out your own thinking, your conclusion that you reach by your heart, your inner feelings that it is his fault or it is her fault. No, it was not the manufacturer's fault. Because the principle clearly says that the owner has to maintain the equipment. So answer C, option C is the correct answer. Coming to our next case, there are two principles in this. Okay, so in such questions you have to make sure that both the principles are fulfilled. The conditions which are laid down in principle 1 and 2 both have to be fulfilled, and according to that you have to select the best answer. Bigamy is not permitted under Hindu Marriage Act. What do you mean by bigamy? Bigamy means having two wives or having relations with two women or two men. Okay. Principle 2 says that a Hindu person of sound mind can adopt a child of the gender that they don't already have a child of. This means if they have a son, they can adopt a daughter, or if they have a daughter, they can adopt a son. Pretty simple. Okay, coming to the facts now. Mr. Preetham is part of a Hindu Vaishnav family, so he is a Hindu. So this act will be valid on him, where all the members have more than one wife. He married Sona in 2006 and he has a son with her called Pyare. He then marries Mona in 2010 and they don't have any children. So our question is, can Preetham, who has married two women, can he adopt a son with Mona? Let us have a look at the options. Option A says that yes, he can adopt since he and Mona have no children. Is this correct? No, he cannot adopt. Why? The correct reason is in option B, because he already has a son. The Hindu Marriage Act clearly states that someone who has a son cannot adopt another son. They can adopt only a daughter. So this option is correct. But we also have to look at the other options. Maybe we will find a more correct answer. The option C says that yes, he can adopt because he is legally entitled to adopt since he is of sound mind and has the consent of his spouse. See, this condition is met. He is of sound mind and he also has the consent of his spouse, but he is not legally entitled to adopt. Why? Because firstly, he already has a son, and second, he is also against the rules of the Hindu Marriage Act. Okay. Finally, the fourth option says that no, he cannot adopt because Mona is his second wife. See, the second principle does not mention anything about having a second wife or about bigamy, which can be an obstacle in adoption. The second principle just mentions the rules about sound mind and the boy girl rule for adoption. So option D is not correct. Okay. So our answer is option B. Okay. The next case says that the principle it says that whoever stores a substance that could potentially cause damage on escape shall be absolutely liable for any damage caused by the escape of the substance from its premises. The person will be liable for the tort of negligence. So it says that if you store any substance which can damage some person's property or health, if it escapes, then you are responsible for that. You will be liable for the tort of negligence. So let's look at the facts. Mr. Jack and Sparrow are two scientists. They develop a pill. Pill means a tablet that has multiple functions, including radioactive properties. Radioactive means it emits radiations. Radiations are harmful for human beings. Okay, some radioactive materials like uranium, polonium, they emit radiations which are harmful to humans and also other living beings. So, they are still experimenting on it, and hence the pill is stored safely in a glass container. We can see that it is stored safely. Only Jack and Sparrow have access to the lab. One day, there is an earthquake, and the effects are also felt in the lab. As a result of the quake, the glass container falls and breaks, thereby releasing the capsule. So, the glass container has fallen down and it has broken, and the pill has reacted with the hydrogen in the air and it has started shooting sparks and it has burst into flame, releasing gases. William, who lives nearby, hears this commotion in the lab and goes in to see what is happening. Later, he sues the two scientists, holding them responsible for his exposure to the fumes in the lab due to the pill. Will he succeed? The point to be noted here is that William has gone to the lab by himself. Okay, the gases have not escaped the lab, they are in the lab. That container has broken, it has fallen and broken, the glass container, but the sparks and the flames are all inside the laboratory. So let us look at the options here. The first option says that yes, he suffered due to the escape of the pill. Is it true? No, he did not suffer due to the escape of the pill. He suffered because he went inside. Okay. B option says that it was an act of God. Well, this can be correct. It was an act of God. Earthquakes are an act of God. Man cannot control it. But was the suffering of Mr. William due to God? No. It was not due to the earthquake. He was not injured due to the earthquake. He was injured due to the exposure to the radiation. So option B is also not correct. The option C says that yes, the two scientists should be held guilty for the tort of negligence and should compensate William. See, this does not give any reason why it should be done. It just says that they are guilty for negligence. But are they guilty? They did take precautions. They kept the pill in a glass container, they sealed the container, they did not give anyone access to the lab. So this is wrong. The final option says that no, they cannot be held guilty because there was no escape of any fume and hence no negligence. As I've already described to you, you have to pay attention to facts. Okay, the fact clearly said that there was no escape outside. It said that the glass container had broken and the gases reacted with and the pill reacted with the hydrogen gas in the lab itself. So option D is the correct answer, and Mr. William will not be given any compensation. The principle in this case says that conversion to another religion solely for the purpose of marriage is not lawful, and such marriage will be deemed to be void from the beginning. So the fact says that Ravi Narayan was born in a Hindu family in Varanasi. His family shifted to Muzaffarnagar when he was 5. Most of Ravi's school friends were Muslims, and since he spent a considerable amount of time with them, he started admiring their customs, their religion, practices, festivals, etc. He was married off to Ravina soon after he graduated, and they had a son 1 year after that. Ravi decided to formally convert to Islam on his son's second birthday. So you can see that he converts to Islam almost 3 years after he marries Ravina. So 3 years after his marriage, he has converted. Now a few years into his marriage, they started having problems and they fought often. Tired of this, Ravi started spending most of his time outside home. He would frequent bars, and in the process, he met Karishma and fell in love with her. He decided to get married to her through his marriage, though his marriage with Ravina subsisted. Subsisted means it is continuing, it is also going on. Is this second marriage legal? Now, you need to decide here that despite having one wife already, Ravina, can he have a second wife? Now, the fact that needs to be considered here is you might know that in Islam or according to the Muslim personal law, four marriages are allowed. Okay, so Muslims can marry legally 4 times, they can have 4 wives. This is the reason you might have heard that many Bollywood actors like Dharmendra, when they want to marry for a second time, they often, without divorcing the first wife, they often converts. For example, Dharmendra converted to Islam before his marriage to Hema Malini because he did not want to divorce his first wife. So that is why this question is based on such facts. But you need to know only about the facts which are mentioned here and the principle which is given above. So let's have a look at the options. The first option says that yes, his second marriage is legal because he did not convert to Islam solely for the purpose of marriage. Is it true? Yes, this is true. He did not convert to Islam for the purpose of marriage. If you remember, he converted to Islam on his son's second birthday. That was before he met Karishma and he wanted to marry Karishma. This was before that. Okay. The second option says that no, religion is not a joke and should not be changed as and when one pleases. This is a very moralistic or preachy option and you should cancel it out directly. We have no mention about this in our question, in our case, in our principle or facts. The third option says that yes, it is perfectly acceptable since a lot of actors and actresses have done the same too. As I already told you, the case of Dharmendra, Hema Malini, etc. But this has got nothing to do with our question, so it was just for your information that I told you. So this option is also cancelled out directly. The fourth option says that no, the second marriage is not legal because Ravi's first wife was still alive. Well, this can be true, but we have no answer to this. See, the fact that Muslims can marry legally 4 times was what I told you. It was not mentioned in the facts. Okay, I told it to you deliberately to confuse students so that sometimes your assumptions, your pre-knowledge, your preconceived assumptions, your notions that you have, they can mix with your opinions, they can mix with your facts. Okay, so this has to be prevented. That is the reason I told you the fact about Dharmendra and Hema Malini. Okay, again here this is not correct because Ravi's first wife has got nothing to do with the second marriage. In the facts, it is not mentioned anywhere that you cannot have a second wife with the first wife still alive. So only option A is correct, and that is our answer. Again, for this question, for this case, the principles are same as the previous one. Okay, it is, you can consider this another example, another part of the same question. Here, Mr. Chulbul belonged to an upper caste Hindu family. He was married to Sheila without his consent. As it happens many a times, it was an arranged marriage, so he is married to Sheila without his consent. Now, Chulbul was in love with Mumtaz, whom he lovingly calls Munni. So, some of you might know where this is going. Mr. Chulbul Pandey, Sheila, and Munni. These names are from the famous Salman Khan movie Dabang, as you might have guessed by now. Okay, coming back to the question. Chulbul was in love with Mumtaz since his college days and wanted to marry her but could not tell his family since Munni belonged to a Muslim family. Soon after his marriage with Sheila, they started having problems. He would come back home drunk every night and talk about Munni in his sleep. As a result, Sheila started nagging him and eventually he decided to divorce her so that he could spend the rest of his life with Munni. Now, however, Sheila refused to divorce him. After several tries, Chulbul finally decided to convert to Islam and then he married Munni. Which of the following statements is true? His marriage with Munni is valid since it is permitted by Muslim law. Now, here, this fact, which I also earlier told you, is not mentioned anywhere in the facts or it is not mentioned anywhere in the principles. So, this is by default not your answer. You should not mix your knowledge with your facts. Second, his marriage with Sheila becomes invalid as a result of his second marriage. Is it said explicitly anywhere in the facts that if you marry for the second time, your first marriage is void? No. So this is also wrong. The third says that his marriage with Munni is invalid. Is this correct? Yes, this is correct. Because as you remember, if you remember the first principle, please have a look again. The principle here was that conversion to another religion solely for the purpose of marriage is not legal, is not lawful. So here Mr. Chulbul has converted to Islam only to marry Munni. So this is not legal. Hence, his second marriage with Munni is invalid, and this is our answer. The fourth option says that his marriage with Sheila is void ab initio since it was without his consent. See, first of all, ab initio means from the beginning, from the initial time. But do we have any information whether you need consent for marriage? No, it is not mentioned. Yes, it is mentioned that the marriage with Sheila was without his consent. But if a marriage is happening without consent, it cannot be void. Okay, it is not mentioned in the principle or the fact that such a marriage is void. So our answer is option C. Coming to our next case, there are two principles in this scenario. The first principle says that culpable homicide occurs when a person causes death by doing an act with the intention of causing death. First of all, what do these words mean? Culpable means punishable and homicide means murder. So it means that punishable murder occurs when a person causes a death by his acts, okay, with the intention of causing death. This is very important. This is the word which you need to pay attention to, with the intention. Now the principle 2 says that intention is a person's awareness of the fact that his or her conduct could lead to the death of a person. Okay, the facts here are, there's a certain Mr. Dutt. He is fond of hunting, and in the game season means hunting season, he went to the dense forests of Madhya Pradesh along with his close friends to indulge in his favorite sport of hunting. For 3 days he found no game. Game means the hunt. Game means the various animals which are hunted. They are called game. Okay, and he returned to his tent disappointed. However, on the fourth day, he went to the forest early in the morning. He saw some movement in the bushes, and this was accompanied by the sound of rustling of leaves. Certain that he had finally spotted a deer, see, he is certain that he had spotted a deer. He thanked his luck and shot at the bush, but unfortunately, he discovered that he had shot a human being. Feeling guilty, he immediately intimidated the forest officers, and they confirmed that the man who was shot was a poacher. Poacher means someone who hunts animals illegally and sells their skin and tooth and other parts for profit illegally. So poacher means an illegal hunter. So the police were in search of this illegal hunter, and they, instead of punishing Mr. Dutt, they rewarded him for his act and commended his bravery that he had shot a poacher. But is Mr. Mrityunjay to be held responsible for culpable homicide? This is what we have to decide in this case. I have already told you the meaning of the words culpable and homicide. The first option says that yes, since he killed a person, but was he intending? Our second principle clearly mentions that intention should be there to kill. Now, did he have any intention to kill a person? No. Mr. Dutt did not have any intention to kill someone, especially a human. Did not have intention to kill a human being, okay? He intended to kill an animal. So option A is wrong. Option B says no, since he helped the police by killing the poacher. Now, he did not know that he was going to kill a poacher, and he was going to help the police by doing that. So this is totally wrong. This is some information which we are not sure of before the event happened. Okay, option C says that yes, since he should have checked whether it was a deer or a human. See, in a jungle usually there are no humans present when you go for shooting. So he's already hunting for 3 days, and he cannot check whether it's a human or a deer. Okay, some of you might feel that this answer is right. Yes, even I feel that this might be right, but we do not have any technical information. This answer is not based upon technical facts which are given in the uh, case. Okay, so option D, which says that no, as he did not have the intent to cause the death of a person, so he should not be held responsible for the homicide. See, this is correct. You can see that he did not have the intent to cause the death of a human. He wanted to kill a deer, he wanted to kill an animal. So it was a mistake which happened with him by him. So you can say that since he did not have the intent, our second principle here is not satisfied. Okay, intention was not there, so it was not culpable homicide. For culpable homicide to occur, there should be intention. Since there was no intention, this is not a culpable homicide, and answer D is correct. Thank you very much for watching the video. I hope this clears your doubts in legal reasoning and prepares you for the upcoming exams. All the best.